All right, ladies and gentlemen, while we're settling in, I want to go ahead and call this meeting to order of the Public Safety and Homeland Security Committee. The first item on our agenda is going to be HB 640. Representative Tyler Paul Smith of the 18th will be presenting House Bill 640. We have two additional meetings scheduled for later on in the week. We have a subcommittee hearing tomorrow, and then a full committee meeting again on Wednesday afternoon. My thoughts are, as we're going to hear HB 640 and HB 534 today as a full committee, I asked the committee to convene today to hear these two pieces of legislation because I think they're both very important. I have my personal feelings about HB 534, and I also have some feelings about 640. I know those are two issues that are at the front and center of debate quite frequently. So it's the will of this chair to hear these bills and perfect them as much as possible before we send them over to the Senate. So Representative Tyler Paul, if you'll come to the podium, please. There should be a sign-up sheet. We have it here. If anybody else wishes to give any testimony when we have public comments, if you would just raise your hand, we want to recognize those and give as much time as possible, considering brevity as well. So to my sweet mate, my friend, Representative Smith.
Thank you, Mr. Chairman. Good morning to all the members of the Public Safety Committee. It's great to be with you. I'll open by saying this. I was reminded of an old Warren Zevon song this morning, not Werewolves in London. It's actually Lawyers, Guns, and Money. And I would think this bill kind of touches on all of them. So I implore you to go check out that song. It's one of his best. But anyways, I bring before you today HB 640. There's a substitute to HB 640. It is LC 413050S. And I believe y'all should have a copy of that substitute. And just to let you know, I had some concerns with the original bill concerning assault, so we took that out. But I'll go through the summary of what this bill does. In Section 1, this actually places churches on the same footing as all other private property. With other private property owners, it's up to the property owner to decide whether to allow weapons and use the criminal trespass laws to enforce it. For whatever reason, we were treating churches differently than other private properties, so this brings them on an equal footing with other private properties. Section 2 of the bill, this would require probate court judges to accept Georgia weapon license applications. I know there have been several lawsuits concerning this, filed by different interests in the state. There are still, to my knowledge, many that are still not accepting these applications or requiring several month wait times on account of COVID. I understand there's a huge backlog, but this is still affecting our Second Amendment right. So it's very important for us to take a look at this and remedy these, in some instances, arbitrary denial of people's right to concealed carry. This section also clarifies when people with drug convictions can become eligible for weapons carry license. These convictions must be misdemeanors. You'll note that felonies are lifetime prohibitions. Right now, as it stands, second conviction for a misdemeanor drug offense, that does not include manufacturing and selling of drugs. And this provision would also strengthen the prohibition against creating databases of weapons carry licenses and sharing. There have been instances of different agencies within the same county saying that they are the same jurisdiction, so it's okay to share. And I'll just give you an example real quick. Say you had a sheriff's office, say you had a county police department, and a Department of Public Health. There's potential right now, as the law stands, for them to create a multi-jurisdictional database within the same county. So this actually prohibits that from occurring. Section 3, it prohibits municipalities from banning discharging firearms on parcels of land 10 acres or larger. It should be noted that discharges are still subject to reasonable regulation, but they cannot be prohibited. Section 4 requires municipalities that have seized firearms to auction them off at least once every 12 months, so they are not just stockpiling them. We have instances of certain agencies, not all. A lot of our agencies do a great work, and we appreciate the efforts they make to help protect and keep us all safe. But there are certain municipalities that are just sitting on large caches of weapons. It should be noted that all transfers must go through a federal firearms dealer of the purchaser's choice, and background checks will be required for those federal firearms dealers. Section 5 repeals power to close gun stores during emergency. Section 6 waives sovereign immunity for instances when private right of action is created. And Section 7 gives civil immunity to property owners who choose not to ban weapons based on a theory that the property owner could have prevented an injury by banning weapons. So that's our summary for you. I believe we provided y'all with all the code sections that this affects. You'll note that there are creation of new code sections within the bill. And so obviously I don't have that code section for you. It's written there in the body of the bill, but I have those for your reference. I know I'm a little aggravated when I can't just have a code section in front of me. I know attorneys have a little bit of a leg up. We can, and legislators do too through Lexis if you opted into that, where you can look up the code sections, but that's for your convenience. What I'll do for subcommittee tomorrow, I will actually give y'all some of my personal notes of which lines are affected within the code section and just make it a little bit easier for you. But today I just want to provide you with those code sections for your personal study. And I'll entertain any questions.
I'm sure we'll have some questions from the committee members here today. Any questions from the author of the bill before we hear testimony? To my friend Chairman Powell.
Thank you, Representative. Mighty good bill you drafted up here for a freshman legislator.
Had a little help, Mr. Chairman, as you recall. I appreciate yourself and Chairman Jaspers for helping us out, and Chairman Collins as well.
You know, one of the things we've looked at is this is just continues to clean up a lot of issues that we've dealt with over the years that needs to move forward to get these more clearly identified. And one of the ones that I hear the biggest amount of angst about is coming from legal citizens who apply for a concealed weapon permit. Now, given the fact that we don't have what was called constitutional carrying and things like this, that made it even more important that the probate judges in the system continues to go. Now we're going to ask. I talked to the probate judge. They want to know who, and they kind of stumbled when I mentioned one county, but whether it's Warner County or any of them. But there's some thoughts that I've had over the years. One of the thoughts is that maybe we need to go to a system where a Georgia citizen can petition for a concealed weapon license in any county, in any probate judge, not just to the probate judge of the county or where they are, which might relieve a lot of the anxiety of folks in certain counties that are having problems getting these applications processed. Second idea would be maybe some general information that we put in that particular language on the application process, that if a probate judge does not fulfill their duties of getting a probate license, go through the process and whatever, within that time frame, I believe it's 30 something days or 30 days or something, that they've got 32 days, 2 days, 30, 20, that if they can't get it done in the 20 days, then maybe we need to consider putting in a clause in there that any citizen that under normal conditions would be eligible, that they could exercise their right until that probate judge gets that issue ordered. Those are just some thoughts that as we move forward in the process on this that we could look at. But overall, pretty good bill. Thank you.
Thank you, Mr. Chairman. I'll just note that, you know, with this bill, and, you know, we've all got concerns and we've all got a lot of legislation coming through the General Assembly dealing with response to COVID. Well, this not only responds in part to the loophole that we're seeing being taken advantage of. Usually the law and lawmakers are reactionary to things happening. And so this is, I would submit to the committee that it's not only reactionary, it's proactive, because we didn't really foresee what this situation was going to be about a year ago. I just sent the Representative Mathis a picture of us qualifying this time last year, and we didn't have masks on. We would have never thought that this would occur. So this is what I would consider a lot of good foresight, and I appreciate both you and Chairman Jaspers for having that foresight. And we actually have an enforcement mechanism in here, like you pointed out, Mr. Chairman, that these, what I would call arbitrary denials of your Second Amendment rights, we have a way to go and enforce the probate court judges to do their job. More specifically, and you know, arguably you've got a writ of mandamus that you could bring to enforce them to do their job, but really get people's attention, you got to get in their pocketbook. And so this helps do that. You got to, you know, those monetary fines, that gets people's attention. So I appreciate it, Mr. Chairman.
I appreciate your commentary, and you're going to make a great addition to this body. And I do.
Thank you, Mr. Chairman.
You know, and I don't want to seem like I'm bashing at probate judges. You know, under most conditions, you know, most of the probate judges I know, you know, they're believers in doing their job and forthwith. We do have some, as we all know, in politics, that some people are elected to various positions that they also have their own views about slowing things down, such as Second Amendments and things like that. And, you know, overall, I think they do a good job. I remember in past years' testimony when that idea was thrown out there about letting a Georgia citizen go to any county to a probate judge to apply. Well, I remember the response came at that time, no, we don't want to do that because that's going to cost us revenue, because they do get a revenue stream out of that. So, you know, those are just some thoughts that we need to look at, but I don't mean for any of this to paint all of the probate judges with the same brush. There's only a few of them that, and of course, with this executive order from the Chief Justice about dealing with the courts, and we know that the probate judges they've had an unusually tough road of it through this virus with a lot of those, but maybe there's some innovative ways of getting some things done to move this process on along, because there's nothing that's more important, especially in this day and time, of your Second Amendment rights so that you can protect yourself and your family.
Yes, sir. And thank you, Mr. Chairman. I'll say that I appreciate the short dialogue I was able to have with the probate court judges outside. And I'll just commend my own district's probate court judge, Judge Holson, Judge Haney. They have really tried their best to move through weapons applicants. I do a little probate work from time to time, and every time I'm in there, they've got people applying for carry permits. So just shout out to them and all the other probate court judges that are doing their job. And I appreciate the question.
Chairman Jaspers.
Thank you, Mr. Chairman. Thank you, Representative, for carrying this and working really hard to understand it. And I'm glad you're an attorney, because this is a very legal bill. I too just want to echo Chairman Powell's comments about probate judges. I mean, you know, this is one of those that when you're hitting on somebody, they're going to push back. And, you know, in my county, Judge Lindsay has streamlined a process that to a fine tooth comb. He's really done a great job, and I appreciate him doing that. Maybe his way of doing it can be spread out. But just got a question on, look on line 83, just in section 3 real quick for me.
Yes, sir.
I think we had talked just a little bit about, this discharge of firearms. It might, brought up to me yesterday that we might need to change that maybe to weapons so that it includes archery, because there are some who would like to prohibit the use of archery, which is
I'd be acceptable to that. I don't know, I'm sure several of you have been able to have the experience with shooting a bow and arrow. It's a lot of fun and it's a whole different kind of marksmanship, so to speak. So I'd be amenable to that.
I would take one exception to that, if I may, Mr. Chairman.
sure, please.
I certainly wouldn't want anyone shooting a cannon. I think the more specific we can be in that piece, in that line.
Sure, okay,
I think there are some unintended consequences of if you just say a weapon.
sure. It is broad definition. You're
Yes,
right.
very broad definition.
Listen to the chairman.
Well, we used to shoot a cannon. We used to shoot a cannon out in Villa Rica, Georgia, until the population grew and we had to cut that kind of stuff back. So we had a mayor out there that would allow some activity.
Here, here. That's all.
Number 7. So Representative Jackson.
Thank you, Mr. Chairman. Representative Smith, thank you for bringing this bill. In section 1, you talked about places of worship. Why was line 4 struck in there about bringing places of churches to the same level as other private properties?
Yes, sir. So I appreciate the question, Representative Jackson. And so what we have right now, if you look within that code section, which I provided with you, it's dealing with the penalty phases.
Okay.
And the way you read it, and this may be up to interpretation, and I'm sure my prosecutor friends can probably help me with that, but it seems to be by just walking into a place of worship that has not opted in to allowing or has not allowed concealed carry within their place of worship, that just by walking in without knowledge, they don't have anything posted about whether they allow for concealed carry, you're automatically in violation of the law if you just walk in there concealed carry. So there's no intent as a part of that. So that's part of that subsection, in addition to placing churches in the same level of other private properties, because they are still, in certain circumstances, you would be considered a private property owner as a congregation, but this is kind of singling them out as what you would say is, a government entity. And I don't think that's what we're trying to achieve in the state, but those are kind of dual purposes of that being stricken from the code section.
Okay, thank you.
Satisfy your question there, Representative?
That did.
Okay. Who is number 14 down there? Is that Representative Holcomb?
Says 29.
Somebody down here on the right side.
Oh, it is 14. It's a different number. That's me.
To my seatmate, go ahead.
Thank you, Mr. Chairman. Can you give me an example of actual damages on line 61 or 72?
So that is something that we've had a little bit of a question about, and we've looked at it. It's hard to ascertain just yet, and I think that's why you would have the $100 fine as well, in case you did have a problem with ascertaining what that amount would be. I don't know how you would necessarily determine the actual damages part of that, but I think the $100, you're probably looking at the $100 fine being what in most circumstances would be the damage amount that somebody would allege.
And who would pay that?
That would be the probate courts.
Okay. Yeah, I'm concerned about having actual damages if we don't have any understanding of what that is. So that doesn't make a lot of sense to me.
Sure. And I appreciate the question.
With respect to, can you explain what's driving lines 82 to 85 with the limitation of municipalities or counties on 10 acres or more?
So we've got a situation of, and there's an example down in Meriwether County where there was a gun range that had been operating for years. And once the municipality had enacted ordinances, I believe they had zoned area industrial, and the gun range ended up being within a radius that they had set that basically put them out of business due to that ordinance. So what we're seeing is that these municipalities have enacted an ordinance to get rid of, say, gun ranges that are already operating. And so I don't think we want that happening in our state. You still have nuisance actions that could be brought, trespass actions that would be brought if those code sections were to be violated. It's not limiting correcting the wrongs that may occur in these instances that are covered by this section of the bill.
Do you have an understanding as to why they made that zoning restriction? Were there public safety interests? And did you say Meriwether County? And
Meriwether. So if I did my first plea hearing in Meriwether County, if you ever been to Meriwether County, there's not much there. And so you have in these local areas, especially rural, that are really needing to see industrial growth, that you would see that they're going to implement certain areas within their counties that are for industrial purposes. And whereas we want to encourage that, we also don't want to basically eliminate situations for firing ranges like we saw in Meriwether County. So that is something that we need to be aware of. And I believe that this code section here and the changes that we propose to it would help keep that fine balance between the county being able to promote industrial growth while also protecting our Second Amendment rights as well, and the rights of private property owners to have discharges of firearms in their property.
Do you have any examples other than Meriwether County?
That's the only one I have right now. I can try to find more for you by subcommittee. I don't know if you'll be in the subcommittee or not, but I appreciate the question. I'll get more of that for you.
Okay, thank you.
Representative Holcomb, I had a question for you, just to kind of help perfect the bill and move it along. On line 61, you were questioning the $100 charge.
Yeah.
If you don't mind sharing with the committee what you charge an hour, what an hour's worth of your time is worth, maybe we could put that on the bill. How
Well,
about
Mr.
that?
Chairman, it depends. And if you want to give me, free advertisement, a lot of times I charge nothing. I do a lot of pro bono work for veterans and others, but many others, I'm probably too expensive for a lot of folks in this room.
There you go.
That's okay.
We appreciate your honesty there.
Yeah.
Any other questions for the, 23? Who is 23 down that way? Is anybody there? Okay, all right. Any other questions for the author of the bill before we open up for testimony? All right. I have Mr. John Monroe. I believe he is on Zoom. Is that correct? Anyone else? Is there anyone here in the audience that would like to speak to the bill? I don't see anyone else here. If you just please come forward. Tell us who you are.
Good afternoon, or morning. Good day. I'm Kelly Wilk. I am currently the president of the Probate Judges Council. I appreciate the information. I appreciate the opportunity to speak. Representative Smith, my husband's a musician and often plays Lawyers, Guns, and Money, particularly when I'm in the audience, so you guys can hang out. The Probate Judges Council has historically tried very hard to stay in our lane. We do not want to get into a political discussion about policy. We try very hard to stick only to procedures that will impact the function of the court and for our workers and for our constituents. So this is not a policy discussion from us at all. And I want to just make sure that I stay out of that side of things in a judicial posture. So my views are not important. The law is what is important. I also want to make it very clear that there's well-settled law that a concealed carry permit does not equate to a Second Amendment right. They are referred to as the same thing often, but one does not need a carry permit in order to exercise their Second Amendment right. And they are often conflated and compared and equalized incorrectly in legislation and in discussion about legislation. So I want to discourage that unequal equation. Third, I am not going to say that this has not been a rocky start or a rocky continuation for the probate judges. As of yesterday, we hit 100 positive cases for probate court personnel in the state of Georgia. We've lost 3 judges. We've had 33 of our probate judges test positive. We've had 67 of our clerks test positive. The process for taking in a carry permit application involves meeting for a new application, involves meeting with an applicant who fills out an application, signs the application, signs the electronic version of the application, has their picture taken, and then has to have their fingerprints rolled. So someone, either in a law enforcement agency that has a contract with the probate court or in the probate court personnel themselves, have to physically stand next to an applicant, touch their hand, roll their fingerprints in order to submit them down to GCIC to run a background check. So when we were told that there was an emergency and we needed to implement PPE in order to keep our personnel safe, we determined that because carry permits were not a Second Amendment right and that people had definite, clear rights independent of their carry permit entitlement, that we needed the opportunity to put in plastic sheeting, to put in hand sanitizers, to order and receive gloves, to order and receive masks. If you remember, on March 14th, 2020, not a lot of us had 3 or 4 masks in the glove compartment of our car like we do now. So we needed to get those things in, and they weren't readily available to a lot of our counties. By mid-May, we had received those. We had worked throughout our policy and our procedure recommendations in our council, sent out best practices, and recommended reopening in mid-May, far in advance of things like jury trials, which are still struggling to get back on course. When we could reopen safely, we did. Safely is a very variant criteria between various counties. I can speak to Cobb County fluently. I can't necessarily speak to any of the other 158 as fluently, but I'll be happy to get you any information that I can. Since we came back on board, Cobb County has required appointments. Our office space for weapons carry license has, if you think of it like a bank teller, we have 3 forward-facing clerks. They have appointments every 10 minutes for new applicants throughout the day. We work in some marriage license folks in there, but the vast majority of our applications are weapons carry licenses. We also put in a policy that now renewals, because we don't have to do the fingerprinting on renewals, those are done by mail-in, and we use the old picture and the old signature. When I was running for office in 2007, 2008, we were doing about 3,500 weapons carry license applications a year. In 2015-16, we jumped up to about 12,000 weapons carry license applications a year. Last year, we did 15,562 weapons carry license applications in 10 months, reflecting the 2 months that we had to close to roll out the PPE to protect our folks in spite of the 100 positive cases. This year, with appointments, we are on pace to take in 21,000 weapons carry license applications. We have 4 people in our license division. We had 2 people in 2007. We will need an entirely new footprint if we are to implement a first come, first serve and an inability to respond to on the fly emergencies. If we are unable to pause or suspend in the case of a courthouse shooting, in the case of a courthouse bombing, in the case of a power outage, if there's lack of connectivity with GCIC, we won't be able to process those. We won't be able, I can't in good faith tell a 10 to 15, maybe $15 an hour clerk that they have to sit at their seat during a active shooter situation to process a weapons carry license. It doesn't make any sense. We need to be able to be responsive. I fully accept that there are people that we need within our ranks to address. There are people that we need to work with. There are people who are not necessarily living up to the standard that we would all set for ourselves. I'm sure that that's true of you and your colleagues among your body. Those people are currently responding to writs of mandamus because there is a legal response. There is a remedy. This is not, with all due respect to the concerns, I share the concerns. We want the constituents to be treated well. We want them to be served. It's one of the duties that we signed on for as constitutional officers to carry our weight. But we cannot be held to a there is no way that you can ever stop processing these and that you have to always do it our way. We have 159 offices. They are all configured completely differently. Some of them intermix people who are showing up from the hospital seeking emergency guardianships of their spouses who they just dropped off at the emergency room with weapons carry licenses. So we're going to have first come, first serve applicants who come in and stand right next to somebody who's just spent 2 to 3 weeks caring for their COVID positive loved one while they're all waiting for services. We can't do that. We have to implement some kind of crowd control. We continue to develop our PPE. We continue to develop our processes. We continue to work with our colleagues to improve around the state. And we absolutely want to carry out our duties. We're elected too. Besides just being decent people who want to do our job, we want to do it safely. We don't want our colleagues to die. We don't want our applicants to die. We want to do right, but we need to do it safely. And we need the flexibility to get this done. And I'm concerned about the exponential costs following something like a Sandy Hook event where we had a 3-time unloading of applicants. Understandably, immediately after Sandy Hook, if we can't regulate the flow of people into our office, I don't know how to staff for that. I don't know how to budget for that. I don't know how to work with the sheriff's office to keep safety in the courthouse. If I have people lined up at 9 o'clock that I can't get to by 5 o'clock, do you think they're going to be any more pleased if they can't be seen and we have to send them home to come back tomorrow and stand in line again? We're doing the best we can with a very challenging situation, and we would beg of you to allow us as constitutional officers, elected officials, and judges to do our best to implement processes and procedures that work for the circumstances as we find them on the ground, and to communicate with us for individual issues.
Thank you. I think we have a few questions for you, if you don't mind standing for questions.
Certainly.
Chairman Powell, if you would, please. Well, no, I'm sorry.
All right.
Go ahead, sir.
Thank you, Judge. Cobb County,
Yes, sir.
what we're told is that, and I know that y'all are stretched up that way, especially with the virus and all of that. But what we've been told is in Cobb County is one of the counties that y'all have suspended taking of applications since December and told it would be March. That's not correct?
That is incorrect. We are taking applications. We open up 1 month at a time in advance on or about the 23rd of each month, depending on holidays and weekends. So on the 23rd of each month, since I don't remember when in this last year, months have been going by, we've been able to implement a new appointment process. We've gone through a couple of applications, as you might expect. We had to find one that worked. And so each month on or about the 23rd, we open up a new batch of appointments and people can make appointments for the following month.
I know that, well, and you certainly wouldn't know about Henry County. We were told some of the information we've been getting is that Henry County is they've set September the 16th as the first available time for an appointment.
I do know that some of the counties that have very small footprints in terms of the number of people that they can bring in have had to stretch out some of those appointments. I don't know specifically about her first available appointment. That is going to require significant investment from the counties and from the Sheriff's Association in order to find, like I said, I can only speak true numbers from my county, but I would need a space about 7 times the size of where we were at the beginning of my term, at the beginning of my career 10 years ago, 12 years ago. And Cobb County does not have a 7 times space that is secured in order to handle the type of clientele that we're looking at. And so a lot of the counties really are trying to get through as many as they can. I'll be glad to look into that number. I know that your stats on me were wrong, so I'm going to give my colleague the benefit of the doubt, but I can't tell you that it's wrong.
Right.
But I can tell you that I know that there are some counties that just don't have the resources to move faster.
If I might continue.
Go ahead, please.
And I know that, and I do appreciate your beginning comments. And granted that a concealed weapon permit is not a guarantee of your Second Amendment rights, but in Georgia, it becomes a very integral part of your Second Amendment rights. In Georgia, we allow people to carry long guns. They don't need a permit, shape, form, or fashion. I'm a great supporter of the concealed weapon permit for no other reason than when we instituted this back in the 90s, this guaranteed that people who had already been background checked could purchase a weapon legally without going through that traditional federal Brady Act waiting period of whatever it was. And it gave people a lot of feel good, but it didn't do a whole lot as far as people's rights when it came to the actual possession or the carrying of a weapon. So that being said, given the problems that we're having today, and it's just general governmental problems, not including the other problems that are being created by this virus that we're living with today. So do you think that it might be the possibility that we could probably take that law to say that in light of the fact that probate judges can't process these applications in a most timely basis, that maybe we should put an exemption in the law that would say something to what I'd recommended earlier, that if a citizen desires to exercise their right, but yet there's a downtime for the processing of his license, that if that citizen is under all other conditions legally able to qualify for a concealed weapons permit, that they should be able to exercise that right until that permit is given. Something to that, I know that's kind of rough, but something like that to maybe take some of the heat off of the probate judges, or either just make the the concealed weapon permit secondary to people's rights to carry that weapon or to have that weapon if they're qualified under that same credentials.
On the way down here at 11:09, actually, Director of the FBI, Director Wray, was being questioned in front of the Senate. And there were some specific questions about the rate of applications, that there are record numbers of guns being bought. That the most guns ever bought, I think, were in March of 2020. That 7 of the 10 highest applications to NICS for background checks that have ever occurred were in 2020. My concern is we have seen, and this is a whole other side that we haven't gotten into because you guys are front end focused, we're back end focused. The application, when they've come in, they filled it out, they've gotten their picture, they've signed the pad, they've gone and gotten fingerprinted, we get a background check back. The background checks, I would love to say that they come exactly as you all would expect them to. 1, that they don't have anything on them, or 2, that they're easy to understand, because they are not. They have all kinds of, no offense, director, who is a very good friend of mine. They're full of law enforcement codes and treatments from all. I had a 1927 moonshining charge with no disposition from 1927 from a federal postal law or something like that. Is that a disqualifier under federal and state law? I'm not sure. That takes me a minute to look into. We have to find out, when we have people who moved here from New Orleans, what their background check is, because they got arrested for a domestic violence charge in New Orleans in 1997. Well, records aren't easy to get out of Louisiana following Katrina. So most of the applications that we are struggling to issue within that 20-day period on the issue side of it are all very difficult background checks, special treatments like first offender, but people don't just come from Georgia. So I don't know whether a misdemeanor in Idaho from 1928 or 1987 is necessarily a disqualifier. So those are some of the things that we are challenged with to get the background check, to do the investigation, to make a determination, to get the order out within 20 days. So that's a whole other side of, if we just go to first come, first serve, we don't know how many people are going to come in, and the number of those background checks are going to increase. And according to Dr. Ray's testimony, or Director Ray's testimony, there have been a record number of denials for people who tried to get a gun, but were not legally entitled. I can tell you, I have had applicants who have been convicted of 3 manslaughter charges and served 20 years and swore that they were not ineligible. So to leave it to people to make their own determination as to whether or not they're compliant with state and federal law would cause me as a judge, having seen what's come across my desk in the last year, trepidation. But I think ultimately your question is, should we suspend the requirement of a permit if permits are not obtainable? And I think that is 100% within the governor's jurisdiction when he enters or the local authority, to the extent that they can, that I think that would be the governor's determination in the declaration of an emergency to address the suspension of that requirement, and not the probate judges. And I don't think that it's something that we should legislate around, because I think that it is too fact specific, that if a particular courthouse is bombed and it's going to take a week to get it, does that mean everybody in the county who wants to can carry a gun without a permit? And I'm not sure that we want that to be in a statute as an absolute.
Okay, who's number 15 over here?
I'm 15, but I was hitting it for number 11.
Okay, you're 11. All right, there you go. Go ahead.
Thank you for your testimony. I had a couple questions. Is there currently an avenue for grievances with the probate system. So if I felt as though I had been pushed aside, pushed back, can you just share with me how that process works?
Yes, so you are able to apply, and there are timelines that are set out for, you have 5 days to get fingerprinted, they have 10 days to process, we have 20 days to issue the license. And then what is currently happening is that the probate judges are attempting to deny, because a few years ago, the ability to suspend processing in order to do an investigation of, for example, a New Orleans misdemeanor charge that may be outstanding, where we needed some more time. This isn't how I've done it, but other judges did. They would suspend processing. The ability to suspend processing was removed from the statute a few years ago. We in Cobb County have always denied the application, stated exactly why we were denying it, even if it was not conclusive, because we wanted to tell them exactly what the charge was, that we don't have the disposition, and then we give them an opportunity to request a reconsideration. For all the lawyers in the room, I know it's not technically a reconsideration because you're getting new evidence, but we're trying to make a round peg fit in a square hole. So they have 30 days to submit that information. So we send out an order telling them that they are not, based on what we were able to obtain from the background check and any investigation that we were able to do on their behalf, which is extensive in some cases, we enter an order telling them exactly why they're being denied, and tell them, and we send them a cover letter that gives them 30 days to notify us if they are going to seek to set that aside. So they can, one, do that. They can get us the disposition documents. They can go through GCIC and NICS and appeal and try and clean up their record to get the disposition on the record so we can rerun their history. They can appeal the order because it's a judicial order that they can appeal through the normal course of things. And there is a provision in the code that authorizes them to seek a mandamus if they think that they are being wrongfully denied, which I'm not a huge fan of because I'm not sure that it's actually constitutional, but that's a whole other issue that I'll be glad to talk about another time. But yes, so there are at least 3 or 4 methods for someone to seek.
Yes. You can have a follow-up there. Let's
Okay, and I
keep
have
moving
one
along.
follow-up on that. Can you explain to me as well, there's this time frame in here of 30 minutes prior to, how complicated is that limit going to be for you or other probate judges around the state? Because I know that in my county, we stop at 4 p.m.
And there's a very good reason for that, because people need to come in. Many of them don't have their applications filled out, so they need to finish filling it out. We need to get them to the window. We need to put in all of their information. We need to have them sign. We need to do their picture. We need to do their fingerprints. In our office, we send them to our sheriff's department, and our sheriff's office actually runs the fingerprints. So they have folks that will then start to get overtime, because if we stop at 4:30, by the time we get our 4:30 appointment in, it's going to be close to 5 o'clock. Additionally, our folks, I mean, we're in the weeds now, but our folks have to count down their money. They have to reconcile all of those things. They have to get everything squared away. They have to put the money in the safe, all of that. And they have to be out by 5 because we don't have time allocated for overtime, but we start at 8.
Would
Yes,
you consider there to be a fair compromise on that time frame?
again, I would hate to legislate it unless you are going to put 159 uniform footprints, processes, number of clerks, number of applicants. It's just, I don't feel equipped today to say what that is. I think most of us are an hour and a half, like in our office, we stopped taking weapons carry at 3:30 to allow our sheriff's office time to finish up and get done by 5. But we do wedding, marriage license applications at the very beginning and the very end of the day in order to give them some flexibility, because if we only did it at the end of the day, some people might not be able to do that. So we try to maximize our productivity with that, and satisfy our sheriff's office.
Thank
All
you.
right. Another question from number 10. Who's number 10 down there? Is that Chairman
Chairman
Workheiser?
Yep.
Go ahead.
Thank you, Chairman. Appreciate your testimony. And I'm asking you as president of the organization, not as the Cobb County judge, because the impetus of this bill is that apparently some jurisdictions have used this as an excuse, or it seems to be that way. So has your organization put out any, have y'all had any discussions or put out any memos to say, hey, you're not in the policymaking arena. Your job is to do your job. Have y'all talked about that?
Absolutely. We have encouraged those that we were told were lagging to get busy. We have communicated with folks. We've sent liaisons down to facilitate and encourage and find creative ways to do things. I am cited often to myself as one of those failures, and the information I am told about what I am doing is so far detached from reality. I am not told of anyone, minus the one that Chairman Powell pointed out to me, that I will concede has been a challenge in spite of COVID, that COVID is not the reason, that I have not yet been able to confirm the numbers that I am being cited and the cases that I'm being cited as being the challenges that they are. But I assure you, every time I get a report, either our executive director, Kevin Holder, or I, or both of us will investigate it and respond and do some encouragement and some best practice. And as a council, we communicate regularly about these issues.
Thank you.
Any follow-up? Okay. Number 14.
Thank you, Mr. Chairman. I'm interested in the operational aspects of this that you raise. I'm sympathetic to an applicant holder or somebody submitting an applicant and then not getting a response. And I guess that's what we're wrestling with, is how it's being handled now, reasonable or unreasonable in light of the circumstances. And if it's unreasonable, what remedies, if any, might be available. So can you provide us context of what extent of a backlog was there, if any, prior to COVID-19 and the impact that that's had on the court system?
That's sort of an unknowable number. It's kind of like how many people want the shot that can't get it. Like, we know a lot of people want a shot, but historically, prior to COVID, the vast majority, if not all, I'm sure that there were some that didn't, but virtually all of us did first come, first serve. But the physical limitations of our offices, the restrictions of COVID, and the increased demand are coming together as the trifecta of challenge and an unknowable number, because we've never, ever, ever approached anything like 21,000 applications before. And we're doing as many appointments as we physically can each day. So what's the unmet need at this point? I can tell you that we have someone who is specifically assigned to returning phone calls, in addition to it being on our website, to explicitly explain the policy so that we can get folks in. But I don't have any idea how many people come to it, see that we will open them up on the 23rd, put it on their calendar, and just come back to the website, but would have made an appointment today if an appointment was available.
Okay, let me ask it this way. Was there a backlog prior to COVID-19 across the state?
Across the state, no.
Okay. Do you have a sense of how many mandamus claims are filed across the state?
I know of one that was filed since. I would say it's a handful a year around the state, perhaps. But like, I had one filed against me for somebody who had multiple drug charges. And so it was dismissed. So filed versus legitimate, I don't have that data in front of me.
All right. One question I have for you,
Yes, sir.
ma'am, is that the problem it seems to be is economics, supply and demand. There's such a demand, and there's only so much supply. Is there a specific reason why in statute, and please committee members, help educate me here, why you have to register in the county where you live? I mean, is there a reason behind that? I mean, is it?
One, it is to keep to keep the information local.
Okay.
Two, it is crowdsourcing. I mean, because a lot of people would travel from Paulding and be in Fulton County during business hours, and Fulton County would get an inordinate number of applications and further perpetuate the problem. So it's an attempt, as I understand it historically, to sort of scatter the demand.
But you use the same software in South Georgia as you do North Georgia, East Georgia, and West Georgia. The process is the same. Is that correct?
No. We use the same statewide vendor to issue the actual permit, but things like the accounting
So there is a common
software-
thread.
There's a common thread for the vendor, just like with the driver's license.
Okay.
It's issued the same way, but all of the support materials down to who does the fingerprinting. Some of us do it ourselves. Some of them have, Fulton County sends them out to one of 5 law enforcement
Right.
agencies.
And-
We send them across the hall to the
And
sheriff's
obviously
office.
the process is strong enough to where the validity's never come into question. Is that correct?
The validity
Of the
of,
process of how different counties process these applicants.
not to my knowledge,
Okay.
other than individual complaints about
So we
processes.
believe in the process. There's enough common thread there between the counties that there's no issue with the validity and the sanctity of the process.
We can always improve, but
Okay.
yes.
All right. Number 15 there.
Thank you, Mr. Chairman. This time it was for me, not for the representative behind me. Earlier in your testimony, you stated that we often conflate the Second Amendment rights with the Georgia weapons carry license. Can you explain that in a little more detail?
Well, okay, so we are a different process. We are we run the background check. We issue the carry permit. The carry permit authorizes you to carry guns in different locations, like in your pickup line for your child's school. You can put it in your purse, in your car, whereas if you don't have that, you have to carry it in other kinds of compartments built into the car. And I don't want to get into giving legal advice as to where, because I get that all the time. I tell you if you can get a permit, I don't tell you what you can do with it once you do, but your right to carry in your home, your car, and your place of business are not impacted by a carry permit. Your right to carry into a building or into a pickup line or church or those types of things sometimes is expanded by the virtue of having that carry permit. But one does not equate to the other. You do not have to have a carry permit in order to exercise your Second Amendment rights. Those are independent existence.
So my pushback on that last part of that statement is a woman in today, back in the summer, civil unrest, wanted to go shopping at Walmart, but being delayed in her ability to get her weapons carry license does infringe upon her ability to exercise her Second Amendment right in that situation. So even though I understand technically there's a difference in the Second Amendment and issuing a Georgia weapons carry license, but if you're unable to get that weapons carry license, you're unable to exercise your Second Amendment right to the full extent of, and I get that we can put parameters and safeguards on that, but it seems to me that they can still carry in their car, but when they go into the building to go shopping and then on their way back, say it's at night and the shopping center is not well lit, that person is then vulnerable because they're not able to exercise their right to carry a firearm. So, Chairman Powell had mentioned a few minutes ago too about maybe putting into the definition of law that if somebody's eligible to obtain the weapons carry license and they're lawfully able to carry, even if they don't have or unable to get that weapons carry license because they're eligible to qualify for it, therefore they're able and qualify to exercise their Second Amendment right. So I get what you're saying, but I do see it as an infringement upon somebody's right if they're not able to, especially when they're not able to get the license due to circumstances that are even beyond your control, or if there's a delay in the process because it's beyond the court's control. And I just want to submit to this committee and on record that I think we need to look into that.
And I would restate my position that things that don't impact the procedures of the court are outside of my lane, and I will do what my daddy taught me and stay quiet when I don't have anything helpful to say.
Bless you. Thank you very much. Chairman Powell, you have another comment there, question?
Yeah, just to follow up, and I listened with interest, and I think the good chairman was going in a different direction, but bottom line, as a probate judge, and it was good to hear a lot of the problems that these counties have. And these are budgetary problems. It's not unlike what we experienced with the election this year. You know, people ought to say a lot of things, but our election system was not devised to handle the number and the volume of people that showed up to vote in November. And there's where a lot of the fail safes of the system came. In your situation, and in the situation of the probate judges, because of the virus, because of everything else, and because of the growing interest in the American public about exercising their Second Amendment rights, for whatever that reason may be, because of security, because of whatever that reason. So it seems to me that our systems aren't set up. So that being said, can you give us, not asking you to set policy, but some suggestions of what we can do to make this process more readily available, even if it includes, you know, the comment that I'd made a while ago about a clause in there or something, but nuts and bolts issues. What could we do to make this easier so that the probate judges can move forward to the issuance of this license? Any suggestions?
Obviously, resources, both footprint, resource, personnel, and some increased ability to actively investigate background checks. I'm sure that that those here would agree that we need some very robust increase into background checks in terms of our ability to put in dispositions that would save all of us a lot of time when we're trying to research something. I don't want to speak out of turn. I would like the opportunity to go back, address my counsel, and submit something to you as soon as possible to try and have some thoughtful recommendations from our council as a whole, and get that to you even later this afternoon, if that would be possible.
Would it, go ahead, Mr. Chairman. I got one more thought.
I'd like to hear those thoughts, but you know, we're moving in a short time.
I know.
But sure.
But there's 159 of us, and I want to make sure that, you know, South Georgia has different considerations than we do, and I want to try and
Rural
make sure
Georgia
that-
has a different considerations than the more heavily populated metro areas.
Yes, yes, they do.
Certainly.
But we will get them to you later this afternoon.
Thank you so much.
Thank you.
This is definitely a reach, but to a follow-up to the questions I'd previously asked about the common thread between counties. Would it be asking too much that in a state of an emergency where you do have the needs of probate courts to place a higher priority on other functions, would it be a reach to say you could allow those in one county to travel to another county to receive a permit if applicable?
Again, I think that in a state of emergency, my hesitancy about this bill, if I'm honest, the biggest thing is that we are trying to address potentials with something bigger than an X-Acto knife. And there are a lot of potentials that could have helped at the beginning of COVID, and I assume could help in the case of a courthouse bombing or a shooting or something like that, that would allow us to be more nimble. I'm hesitant to speak in absolute when we're talking about that kind of flexibility.
Thank you. Number 9, Chairman Jaspers.
Thank you, Mr. Chairman. You know, thank you, Judge, for just good, honest discussion, and that's what we're here for right now. But I just want to go back to just a couple of things. This has been an ongoing problem. I mean, back when I worked on, and Chairman Powell and I worked on this issue 6 years ago.
House Bill 60.
The code that's in here today was trying to get to the root of this and getting these things moved through. And we haven't been successful because pre-COVID, this was an issue. We heard it from our advocacy groups and people from our community, that in certain areas of the state, we're just not doing it. But so, I mean, we'd love to hear your ideas on what to get to do that. Just like the chairman said, if you can't do it within 30 days, can they go to another county? I can see a few issues with that. I mean, people, shopping counties, because in the political climate we're in right now, this is only going to accelerate. What you had this past month will grow next month and next month. And it's just what's going to be. And I'd love to hear your suggestions, because that's what we're trying to do. We're just trying to make it better for the people that vote for you and vote for me, if we can. But that's just one question. You mentioned the person that had multiple felonies or drug charges. Did you refer that person to the district attorney for prosecution?
I did.
Okay.
It's a normal process. We do not typically refer folks who have question like first offender and things like that, where they're not sure if they were convicted. But I felt pretty solidly that if you spent 20 years in prison and had 3 manslaughter charges, you'd remember.
Sure. I just want to make sure.
Or you
Thank you
fit
very
under
much.
some other
Thank you very
disqualifier.
much.
Well, I just to make sure the committee members know that
Yes.
that is the process. If they
Yes.
do that, there's not like a free ride.
Right.
This bill is going to go, any further questions at this time?
No.
This bill is going to be in subcommittee tomorrow also. And hopefully we can make some changes between now and then.
Are you done with me?
Yeah, yes, ma'am. Thank you very much. Yeah. If you want to go on back and start issuing some of those licenses, you feel free to go ahead and do that at this time. All right. Thank you, Tyler Paul, for your presentation.
Thank you.
We'll see you in subcommittee tomorrow.
Sounds good.
Okay, the next item that we're going to be hearing, our next bill, is HB 534. And one of the reasons that I asked this to come to full committee, these are some very substantive changes to some statutes that we have in place now. Chair realizes again that this problem is a problem. Again, somewhat isolated to the metro area, in my opinion. But again, it is some substantive changes to current statute. And I did want the committee to pay close attention to those changes and realize exactly what is being proposed in this legislation. So I'm going to let Representative Bonner, if he would, to go ahead, and Chairman Bonner, if you would, please.
Thank you, Mr. Chairman, members of the committee. I appreciate the opportunity to present House Bill 534 to you. I'm working off of LC 392897-EC. And what I'd like to do, Mr. Chairman, is I'll run through some of the highlights of the bill. And then I've got Mr. Trey Bennett with the Governor's Office of Policy available for some particulars. And then we also have some testimony at the pleasure of the chair. So under current law, drag racing, laying drag, those offenses are currently illegal. What this bill seeks to do is to further address the issue of drag racing and stunt driving by providing for the following additional offenses. One is promoting or organizing an exhibition of illegal drag racing or laying drag. And then secondly, the reckless stunt driving. Now, the first offense is aimed at punishing those who orchestrate, facilitate street racing, drag laying, and those related activities, but have been able to escape a criminal liability because they were not personally driving those vehicles. And then the second is aimed at eliminating other types of dangerous driving that do not fit into the narrowly tailored definitions of current law. In addition to the creation of these two offenses, the bill also proposes punishments, reporting mechanisms, conditions for the suspension and revocation of licensure, the conditional forfeiture of motor vehicles used, and other related matters. And Mr. Chairman, just walking through briefly the bill itself. In Section 1, it creates a misdemeanor of a high and aggravated nature for any person who knowingly promotes or organizes an exhibition of illegal drag racing or laying of drags. And then in Section 2, it adds reckless stunt driving to the offenses for which driver's license revocation may be appropriate under Code Section 40 the habitual 40-5-58, the habitual violator section. And then under section 3, it provides for driver's license suspension of any person convicted of reckless stunt driving, and it spells out the various penalties and fines under that section. Moving on to section 4, it adds reckless and stunt driving to the list of offenses for which one could be deemed a habitual violator, and then cleans up some language in that code section. It also removes a provision that pleas of nolo contendere are considered a conviction for habitual violator purposes. Then section 5 provides some more cleanup language related to the issuing of limited driving permits. And then section 6 creates the criminal offense of reckless stunt driving of a misdemeanor and high aggravated nature, and specifies the conviction schedule under that code. And then section 7 through 10 adds reckless driving to the various statutes as appropriate. And that, Mr. Chairman, is again a high-level kind of rundown of the bill itself. I've got Mr. Bennett here available for any particulars that the committee has. And then we do have some folks from our law enforcement community available for testimony as well.
All right, so we got 1, 2, 3, 4, 5, 6 people who have taken time out of their day to come tell us about drag racing and laying drag. Who do you want to start with? The Southern Center for Human Rights?
If we,
Dodson?
well, if we could, Mr. Chair, if Sheriff Labatt is here, and if he would like to speak, or his representative to provide some context for this, I think that might be appropriate.
Please go right ahead.
Yes, sir, Mr. Chairman, members of the committee. I'm Terry Norris. I'm Executive Director of the Georgia Sheriff's Association. I wasn't on your list. I got here a little late, but I want to join Sheriff Labatt and others to stand in support of this bill. There is at least one other proposal pending, I think, in the Senate on this matter. It addresses some of the concerns. However, we have worked closely with the governor's staff, particularly Craig Foster, Judge Foster's son. You may recall him. And I think they put together a very adequate proposal that addresses some of those concerns we had, which particularly had something to do with the eventual seizure of a vehicle and condemnation of that vehicle under certain circumstances. So we absolutely stand in support of this measure and look forward to answering any questions throughout the process and helping move this legislation through. So if Sheriff Labatt, if you'd like to. Thank you.
First of all, good afternoon, Mr. Chair and committee. I am newly elected, as you referred to someone as a freshman representative earlier. I'm the freshman sheriff on the block with the biggest problems. As you mentioned, it is squarely in our wheelhouse with respect to most of the activity, but it has no limits. And so and the bigger issue and concern is because it's a pop-up style of someone's entertainment, it's going to go beyond Fulton County. It is in Cobb County, it is in Douglas County, and this street racing is going to end up getting more and more people hurt. And until we hold people accountable for organizing and participating, then we are not doing our jobs. And so I am certainly in full support of the bill, the Senate bill. I think it's 10, if I'm not mistaken, that is coming over as well. Aims to do just that, is create some stopgap measures. And we hope that ultimately, because people are currently violating these laws and putting people in danger, ultimately we hope that this will really, pardon the pun, right? Take a bite out of crime. And so really put teeth in what we are trying to do from a law enforcement perspective. So I appreciate the time, and I will stand by as well in case there are any questions.
I think you do have a couple of questions. Number 7, is that Representative Jackson?
Thank you, Mr. Chairman. Sheriff, congratulations on being elected to Fulton County Sheriff Department. And hopefully you can stop this before it comes to Washington County. We don't want to see drag racing in our county. One question, does this apply? I I don't live up here, but when I'm up here, I hear a lot of motorcycles, four-wheelers, the noise too. Does this apply to them too, the four-wheelers and the motorcycles too?
You want to speak to that?
Thank you, Representative. Again, my name's Trey Bennett. I'm Deputy Executive Counsel to the Governor. Currently, yes, this is under the vehicle code. So anything on a public road or on private property without express permission. So yes.
Thank
Okay,
you.
thank you. Number 9, is that Chairman Jaspers?
Yes, sir. Thank you. Sheriff, it's a simple question. I'm not law enforcement. Why can't you stop them now? I mean, I saw on video this morning a helicopter over a parking lot. Saw a guy in a Challenger, whatever it was. Y'all arrested them. Is the penalty, is what you're saying here, the penalty not great enough? I mean, I guess, what's the real issue here? Because I can see this kind of, that's my real question.
And so it's not a matter of the actual pursuit and stopping as much as, yes, we have the technology to identify who that person is, but there are no consequences. There is, and I will tell you, I'm from here, right? And I say that I'm from Atlanta, born and bred. And so I know many of the people that have friends that are doing this, is the best way for me to put it. And they'll say, we'll just go buy another car, right? If we seize it. We have to put some bite into this. So we discourage people from even standing around watching it. I mean, it is horrific to see people get hit by these, supposedly these stunt drivers. I don't even give them credit for stunt racing. And so we need you all's help to really strengthen the consequences around that and to discourage it from that perspective. And so really think about the amount of resources that we use, just the helicopter you mentioned, to put up in the air, to then follow one or several cars from that perspective. And when you have multiple situations like that, it really ties up our resources from really doing some things, whether it be emergent services or in a position where we can respond to other calls. So it has become more than a nuisance, as you mentioned earlier, and we certainly want to stop it before it gets to Washington County. And I know that's a concern. So we hear it, right? It goes into the 2-wheel and 4-wheel drive motorcycles, et cetera, but even the noise, right? At 2 or 3 o'clock in the morning, I hear it constantly. And I have made a commitment to my constituents that we will do everything we can, and we need this level of support in order to move forward. I hope that answers your question, Mr. Chairman.
It's my curiosity is that you can arrest them now. Can you not confiscate their car now when they're doing something like this?
You can't seize the vehicle from that perspective. And yes, we can make the arrest, and depends on where you are, right? A larger issue, if they go to the City of Atlanta Department of Corrections, for instance, they'll sign their way out. But even coming to the county, there are opportunities in nonviolent situations. And we are working with the judges to see how we can make sure we strengthen even the bonding procedures around that as well.
Okay, thank you, Mr. Chairman. Mr. Chairman Powell.
Yeah. Sheriff, my congratulations and condolences, whichever one seems to be more appropriate with what you've been gifted to. You know, Chairman Jaspers, his questions were kind of online with what I wanted to know. And I understand that by increasing the penalties, you know, this is the law itself that we can get to them a little bit more. But in the practicality, y'all got a chore on in your hands to try to get this done. As a sheriff, your manpower, do y'all enforce traffic laws even in the metro areas, or are y'all just in the unincorporated, which I don't even know if there is an unincorporated area in Fulton anymore? Do y'all have to work with the Atlanta PD and places like that?
So, and let me help. So there is a 6-mile stretch of Fulton County, which is FIB, Fulton Industrial Boulevard, that is unincorporated at this particular time. Maybe not after the session, we'll see from that perspective. But I remind people, and especially our constituents, I don't have to work with anybody. The women and men of the Fulton County Sheriff's Office are committed to upholding the law. And if anyone breaks it, we will come see about you. Really, that's the bottom line. But we have a great working relationship with all 16, 17 police departments internally to Fulton County as a whole. And so we are, and you didn't ask for this, but I'll give you some inside information. Next week, next month, we are putting on the street a crime suppression team that actually focuses solely on street racing and high priority crimes from that perspective. So we're being more proactive. It's forced us into this space of not just responding to your normal calls, but we want to do, just as you said, Mr. Chairman, we want to be proactive and really cut this off before it starts.
And did I understand in your answer to Chairman Jaspers that y'all have the ability to stop these races now, or is that still?
Well, the ability is there, all right, but the danger is there as well. When you start talking about high-speed cars, how do you strategically come about and put together a holistic plan for the weekend even? And you can put a plan together for the weekend. I'll give you a prime example. We put a plan together for the weekend that's centered around Buckhead. Then we get a call from East Point and have to go over to Camp Creek. And as we're at Camp Creek, I get a call from the police chief in Sandy Springs. And so while you have these pop-up style races, it does take, Mr. Chairman, a helicopter to really identify some of that. And even then, the technology to really put on a helicopter to then track a vehicle of that nature is just terribly expensive. And in most cases, and I certainly don't speak for, I know our executive director, wherever Terry went, is he still like that? He can testify as well. Most sheriff's offices are simply not equipped to put that level of technology into, whether it be a helicopter. A lot of times we depend on GSP. And so when we prepare for that weekend, sometimes nothing happens, all right? And so now we've gathered resources and now we have to get ready for whatever the next pop-up piece is. So the Saturday I gave you that example of, we were running all over the county. I mean, we did other things, don't get me wrong, to make sure we are safe and our citizens are safe. But it is a strange phenomenon that we really need you all support in helping discourage. And it's one of those things that we can stop, and we'll get to that point, but it is the consequences that come along with it.
Thank you so much, you and your brothers and sisters, in enforcing the law.
Yeah, thank you.
8, who's number 8 there?
That's me, Chairman.
Thank you.
Thank you. So, so I am a member of the DeKalb delegation and portions of City of Atlanta and Decatur. And I do appreciate the seriousness of this crime. I want to say thanks to this committee. I got to know the chairman of, public safety last session, and I did have constituents come to talk to me about this crime, and I convened 2 meetings to discuss this issue with DeKalb, Atlanta, Decatur, Law Enforcement, Georgia Safety Patrol, the Solicitor's Office, the Solicitor Generals, DAs, across the Criminal Defense Council and the Prosecuting Council. So, and to be honest, after hearing it about all these things from all sides, it's like I understood it's a very serious crime, but it was not evident to me about what the exact way forward was. So, but I do know that it's a very serious issue. So I'm glad that we're talking about it and that this bill has been brought. I want to thank you for that. And one thing I am glad to see is that there were some calls for, taking the car, immediately after arrest, the seizure. There was a discussion about that. And so I'm glad that this bill does not include that. This is after conviction, that's a possibility that could happen. So, that the car could be seized. One thing that we talked about, and I've heard, and actually a part of one of the people, that I got to know was a detective from DeKalb that does the intelligence, and he talked about the need for this, the first part of this bill. But one of the concerns we heard is what would constitute this evidence? And I don't know if you would want to talk about that, because that is we heard there might be a freedom of speech possible issue, as far as, like how would we decide how they're organizing and promoting? So that may be more be an issue for the attorney.
Sure. Thank you, Representative. First of all, regarding the asset forfeiture aspect that you mentioned, I just wanted to be clear with you. A forfeiture would come into play on a third offense. So you would have
No, I
two
understand
prior
that.
convictions.
No, I do understand that. And actually, no, I'm happy about that. Like there was talk
Great.
at some point when I was looking into it about trying to seize the vehicle right after arrest and keep it, until adjudication.
Sure.
So this does not include that, and I appreciate that. So this is after conviction.
Okay.
Yeah. But what about this first part?
The organizing.
Yeah, the organizing. How
Sure.
would that be proven?
Sure. Our understanding from the concerned individuals that have approached our office, along with Representative Bonner and others, is that a lot of these events are being organized via social media. And, I understand everybody's got a right to speak, but then, for instance, the Supreme Court said, you've got a right to speak, but not to yell fire in a crowded theater. So there are types of speech that would be against the law, such as a terroristic threat, things like that. So under that, it would not be, something along the lines of, hey, I went to a race or something like that. It's these somewhat, professionally created advertisements that are being sent out to advertise this illegal behavior, almost in the way that advertising, hey, I have drugs to sell, would also be illegal. So.
Okay.
Number 4, is that Colonel Hitchens? Yep. Thank you, Bud. Go ahead.
Well, I'm very familiar with the perspective of this, and you're ultimately county, much like my friend here from Washington County. I live on the country on the county road, and I stepped outside at 2 o'clock in the morning, I hear whippoorwills.
Hit your button there, Colonel. Hit your button. Okay, go ahead.
Okay. If I step outside in the middle of the night, I hear whippoorwills and crickets primarily, but as most of you know, I've spent a lot of time in Atlanta, and I have a condo in Midtown on Peachtree Street. And I lived there for 10 years, and it took quite a bit of an adjustment to begin with for the noise and some of the extracurricular activities that go on there in the middle of the night. And when I retired and went home, I only come up here for 3 months a year now. And every time I come, it seems that there's an increase in the activity out there, drag racing. In particular, I've never seen the land drags and the spinning the tires around, but it's very obvious to me what's going on out on the street at 2 or 3 o'clock. I haven't seen anything towards the organizing of it, but I'm sure that occurs. It kind of takes me back. I'm no spring chicken anymore, and I remember the 50s and 60s when we had high-powered cars, and that was pretty much in vogue back then. But I think the utilization of aircraft would certainly put a quick end to a lot of it. But I just happen to know, having been the commissioner of the Department of Public Safety, that it's $1,000 an hour on one of those Hughes aircraft, and that's pretty expensive. You can't afford to just put them up right around town all night looking for them. If something happens, you can put one up and identify them. And when we're talking about high-speed vehicles, first thing they do is they're going to hit one of those exit ramps, and you're going to have a high-speed race out on I-75, I-85, and the possibility of something serious happening is horrific. So, we need to stop this in the bud, and I don't have any easy answer to it. It's just like any other crime. It's a crime of opportunity. They're not going to do it when they see police cars sitting along the street out there, and they're not going to do it typically in the daytime. Now, some of the motorcycles are different. you know, I would call them racing. I've had them pass me out on I-75, 85, running 100, 110 miles an hour with 4 or 5 of them weaving back and forth in cars. And I don't know why more don't get killed than what they do, but it's all a serious danger to the motoring public. And it's a danger to my hearing. I can tell you at 2 o'clock in the morning when I hear the tires screeching and the motor is roaring. And I appreciate everybody's interest in trying to stop it. And I think the penalty phase is the way you do stop it, because people are scared of serious penalties. If they walk in the door and sign it and walk out the door and you charge them a couple $100, you know, they move on and they'll do it again. But you start taking them to court and give them their due process and take their vehicle away from them on the third offense, they can take a different perspective. And that's just my spiel. You know, I'm just thankful that the people are coming together to realize how and these laying drags. I mean, they say they're stunt drivers, but I don't think many of them have the real capability. They'll spin that thing around in the road 8 or 10 times and do it efficiently. But one of these times, one of those wheels are going to grab traction. And when you have a crowd like that, they're going to go right in the middle of it. And 6, 8, 10 people are going to be killed or seriously injured. And then everybody's going to say, we're sorry after the fact. But that's just my 2 cents worth.
We need to hear some testimony from some other people that have came here today. So anyone else that we need to allow some opportunity to speak. Thank you, Sheriff, for being here with us today.
Thank you.
Okay. We want to hear from Director Reynolds. Do you want?
Mr. Chairman, I don't want to take a stand. I just want you to know I'm here supporting Sheriff LaBatt, supporting this testimony bureau. It's outside of our lane, but I just want you to know we're here to support that.
Okay. All right. We have Marissa Dodson online. She's from the Southern Center for Human Rights. If you'd like to go ahead.
Yes, thank you, Chairman. Good afternoon. My name is, can you hear me okay?
Yeah, go ahead.
Okay. My name is Marissa McCall Dotson. I'm an attorney and the public policy director at the Southern Center for Human Rights. We are a nonprofit law firm that focuses on equality, justice, and dignity for people in the criminal legal systems in Georgia. It is because of our commitment to eliminating ineffective and punitive criminal legal responses that we are opposed to House Bill 534. The lessons from the Deal administration about successful criminal legal reforms were based in large part on identifying the best solutions to the problems by looking at the data. This practice is commonly referred to as evidence-based. But House Bill 534 is not evidence-based. It only relies on complaints about the problem in certain communities, specifically Atlanta and Fulton County, and it is not about the extent of the actual problem across the state or based on any proven solutions. The primary reason given by supporters of increased penalties for street racing is that the activity is dangerous and puts Georgians at risk for death or serious injury. The implication is that our current laws aren't enough. Georgia law, however, already has many laws on the books that address dangerous activity on our highways and streets and provide stiff penalties that can include incarceration and onerous fines. Some of these charges include reckless driving, aggressive driving, laying drags, drag racing, driving under the influence, serious injury by vehicle, and homicide by vehicle. Despite the increase in complaints over the last several months, mostly again from the metro Atlanta area, and most often about the noise and inconvenience, there has been no data collected or evidence offered to suggest that this is actually a statewide highway safety problem. We don't even know how many accidents or injuries are related to street racing activities in our state. I think we can all agree that the most dangerous conduct by drivers on our roads is driving under the influence. In fact, studies have consistently found that about 1 in 4 vehicle-related deaths in our state are caused by drivers who are under the influence. Yet, without any such data collected or evidence put forth about street racing activity in Georgia, incredibly, the proposed changes to the law in House Bill 534 are even more punitive than our state's DUI laws. For example, under House Bill 534, a third conviction for reckless stunt driving will be a felony, while it takes 4 convictions for a felony DUI in Georgia. Also under House Bill 534, reckless stunt driving allows vehicle forfeiture after 2 previous convictions, while the state's DUI law requires at least 3 prior convictions for a person's vehicle to be in jeopardy of forfeiture. It is important to note that Georgia's civil asset forfeiture laws impose significant burdens on the person whose property was taken to recover his or her property. House Bill 534 allows forfeiture even if the operator is not the owner of the car. This will create significant barriers for entire families to rely on one car to get to work, school, doctor's appointments, and other necessary activities, particularly during a pandemic, and even if the car can ultimately be returned. House Bill 534 also imposes harsh and mandatory fines of at least $1,500 upon a first conviction. Not even the fourth conviction for DUI carries a fine of more than $1,000. The mandatory fines imposed by House Bill 534 are excessively punitive and get as high as $5,000 for a third conviction. Both the mandatory fines and the vehicle forfeiture provisions of the bill are likely to face constitutional challenge based on the Supreme Court's decision in 2019, the United States Supreme Court decision, Timms versus Louisiana. We know, according to the Governor's Office of Highway Safety, that vehicle-related deaths have been on a steady decline. So there is no sense of urgency despite what you may have heard. And we can take the time to collect data and study the problem that is affecting only certain communities instead of just increasing punishment statewide in hopes that this will be a sufficient deterrent. Not only has the theory of punishment as an effective deterrent been debunked in study after study, we know that purely punitive approaches to street racing activity in particular have not worked in Texas, California, Michigan, or Florida, to name a few. Moreover, we are still dealing with a global pandemic. This is not the time to increase jail populations when jails are frequently sites of high COVID-19 transmission. State lawmakers should be more focused on mitigating the spread of the virus in our correctional spaces, instead of proposing legislation that will increase incarcerated populations and thus potentially also the spread of the virus. Finally, and always important, criminal legal responses disproportionately impact Black and Brown communities. While others can avoid criminal involvement, it is often the case that Black and Brown communities are more likely to receive criminal legal penalties, even when less likely to engage in the activity. Every time we at Southern Center stand against punitive criminal legal responses, we are asked for a better solution. Today, we are encouraging you to consider the creation of a study committee on this issue to better understand this activity and the impact it's having statewide on highway safety. A critical component of an effective approach must be to enlist the support of the impacted community, including car enthusiasts, residents, elected officials, law enforcement, and the business community. This is consistent with House Resolution 120 that was introduced by Representative Corbett and currently awaits a vote on the House floor. That proposal acknowledges a problem with theft of motor vehicles in our state, but seeks to first conduct a comprehensive study before considering changes to the law. It has not been made clear that we need changes to the law in this area. House Bill 534 is not an evidence-based proposal. While it may be intended to deter dangerous activity on our streets, we don't need any new laws in this area. House Bill 534 will not effectively deter street racing. It will only result in harm to families and certain communities, an especially devastating outcome during the current pandemic. We encourage you to do what works so well. Oh, sorry.
Can I get you to wrap it up? We're running a little short on time here.
Yep, we just encourage you to study the problem before you try to fix it. Thank you.
Thank you very much. This is a hearing only. This is going to go to subcommittee. I don't know that the subcommittee will be able to vet this bill in HB 640 altogether, but we're going to try to do some things today and tomorrow to make this bill better. Any further discussion right now? Any other anyone else in the audience wants to speak at this time? Okay, if you'd come up to the podium, please.
Chairman, my name is Maisie Lynn Causey. I'm General Counsel for the Georgia Association of Criminal Defense Lawyers. I've heard what you just mentioned about subcommittee tomorrow. If you would prefer for us to hold our comments until then, I'd be happy to do that. I don't want to belabor the
We want
point
to hear from you as much as we can today. We've got a few more moments here,
Okay,
so please.
I just wanted to make that offer.
That's okay.
A couple of the issues that have been mentioned so far today that I just wanted to kind of follow up on. One is this idea that Representative Jaspers mentioned about this, why can't they be stopped now? And I'm just going to say that enhancing penalties and increasing punishment and expanding our criminal code does not enhance our ability to enforce the laws. So I think it's a relevant question for this committee to consider and to keep considering as you look at this bill. As a threshold matter, though, Gactel is concerned that the commission of this new reckless stunt driving crime can be effectuated without any recklessness or risk to others at all. For instance, this new crime would be complete if someone was laying drag in an empty shopping center. Consider one that might be a long defunct retail big box store with essentially no chance for anyone else to enter the lot. Moreover, it's curious to us how having the express authorization of the owner of the property would somehow diminish this crime and allow it to be less troubling to the proponents of the bill. Because according to the bill, that express permission would prevent one from being charged with this new crime of reckless stunt driving. Of course, you would still be subject to a charge of laying drag, even if not reckless stunt driving. As was mentioned by the Southern Center for Human Rights during their testimony, we're also concerned about the punishment scheme here and the fact that it is higher and more punitive than even our DUI laws. As you've heard, you only need a third conviction under this new law for a felony. It requires 4 for DUI. And the forfeiture scheme is more harsh. And Representative Evans, the one distinction I would make about the forfeiture is it's true that under this bill, for the forfeiture to be an issue, you have to have 2 prior convictions, but the forfeiture does take effect after the 3rd arrest. It's not a 3rd conviction. So it does fall within the window of a pre-adjudication period of time. We do have concerns as well that the vehicle forfeiture aspect of this bill is likely excessive under the 8th Amendment. As Ms. Dodson mentioned, 2 years ago, the US Supreme Court in Timms versus Indiana held that the 8th Amendment's protections from excessive fines applies to the states through the 14th Amendment. And in so doing, they suggested in that case that the forfeiture of Mr. Timms' vehicle, in that case, the vehicle was worth $42,000, was disproportionate to the felony crime in issue. That felony crime carried a maximum fine of $10,000. So you can see when the court was weighing the relative value of the car versus the punitive measures in that particular code section, their punishment scheme in that code section, that would probably hold true in ours as well. Because House Bill 534 subjects certain vehicles to forfeiture when a person's arrested on a 3rd or subsequent reckless stunt driving charge, we believe that this provision would be ripe for challenge under Timms. Both the forfeiture scheme in this new piece of legislation as well as the DUI scheme involve that the actual vehicle owner not be involved in the offense. So you could have someone else could be using your car and your car could still be forfeited even if you weren't the person charged with the offense, which is a huge concern. As you likely imagine, Gactel is generally opposed to the expansion of criminal liability and punishment in our criminal code. In this case, our modest request would be at a minimum that you bring the crime classification fines to a level at or below the DUI scheme. Treating reckless stunt driving more harshly doesn't make sense to us. We're unable to find any statistics on actual harm caused by street racing or laying drag that come anywhere close to the crimes, to the damage that's caused by DUI in our state each year. Now, Gactel certainly appreciates that any needless death is one death too many. But still, the relative potential harm has a role to play in your policy setting, and you ought to take notice of the disparate treatment you're giving of the motor vehicle crimes in our statute. We would also join the Southern Center in a call to a study committee on this issue. There's a lot to be discussed and many stakeholder voices to be considered. And an alternate remedy that was discussed over the summer, Representative Evans was mentioning some of the stakeholder meetings that have already happened, are ideas around streetscaping. As I mentioned at the start of our conversation today, enforcement is one of the problems here, not the lack of crimes available to be charged. And you heard, I think, even Sheriff Labatt was saying how it's hard for them to get from one scene to another when these events seem to be traveling. So one suggestion that's come up, and we would ask you to at least consider, maybe a study committee would be a place to do that, is that streetscaping is a way to cut down on some of this. What came up in the conversations this summer was that it's clear there are certain places where the congregations of people are coming together because the streetscape is ripe for it, right? There's just openness, expansive intersections where bollards could be put in place and other types of streetscaping design that would actually prevent the vehicles from being used in the manner that's problematic. So before you expand the criminal code, we would ask you to please take a step back and consider the issue before you expand our criminal code. We just don't think coming at it from the back end is really the most effective way to truly deal with the public safety issues that are on the table.
Okay.
And if you have any questions, I'd be happy to stand for them.
Thank you. You bring some very valid points that the chair totally agrees with. So thank you so much.
Sure.
Okay, let's hear. You give us just 1 second. We want to hear a little more testimony right here first. Let's see is Butch Ayers with us?
Good afternoon. My name is Butch Ayers. I'm the Executive Director of the Georgia Association of Chiefs of Police. And I'm just here today to let you know that we support the bill and we stand with law enforcement with the need for this bill. It is not an issue that is regulated just to the downtown Atlanta area. Numerous communities across the state do have this issue. And I heard some testimony and comments about how hard it is to actually stop this. And again, you can utilize helicopters, but there's a certain big cost associated per hour to operate a helicopter. Agencies can get together and they can come up with a action plan and do it in advance and say, okay, next Saturday, all these units and a helicopter unit and motorcycles, we're all going to get together and we're going to perform some type of street racing enforcement detail in this location. Well, that's great, but what if it happens the day before, the day after, 3 hours before, the other side of town and things like that? And I think the big thing about this particular bill here is one of the goals is to stop the behavior, or at least make the potential offender think that there are some serious repercussions if you engage in this type of behavior. And it's very simple. It is just the driver or the offender behind the wheel of that car or someone who is organizing a race, that if their behavior is not as such, then there is no penalties to be paid. So, at some point, if they think the behavior is going to be not punished, if they don't feel like there's any type of accountability for their poor behavior, then I think things like this will continue, and especially in a day and age with social media, because these things are filmed from multiple locations inside the car that is racing, from bystanders, and you see it on YouTube tomorrow. But nevertheless, we are willing to work with the committee and work with the sponsor of the bill to improve the legislation any way we can. I'd be glad to answer any questions.
Okay, thank you.
Yes, thank you. It's nice to meet you. One of the things we discussed was about changing points for the different crimes, like the current crimes that are on the books. What are those points now? Do you know offhand, like reckless driving versus lane drag? There's like 2 points, or maybe, I don't know if the bill sponsor knows that, but.
I'm not sure.
Okay. Okay. And does anyone here know about like how many points is it before you have your license taken away? Like, does anyone know that? I'd like to know, I'd like for us to understand that before we hear it in subcommittee.
I think it's typically like if you get accumulation of up to, I think, 12 to 15 points
Right.
before your license is suspended.
12 points. Yeah, that's what I was thinking.
Right.
12.
So
Number 12.
I would like for us to, as we discuss potential amendments to this bill, to think about, increasing or having, what are the points versus automatically going to fine and jail, so that's something that I think, I would like for us to consider. And also I have a question for the bill sponsor about noise, so I don't think it's directly to.
Okay, thank you. Do we have any more questions for Mr. Ayers before he comes? Number 12.
Thank you, Mr. Chairman. I didn't have a question for Mr. Ayers, but to answer the other representative's question, is 6 points for a violation of for reckless driving. Any of the major traffic offenses is 6 points per incident, and it's 15 points before their license gets revocated.
Okay. All right. Thank you. Okay. Thank you very much, Mr. Ayers.
Thank you.
Appreciate you being here. Any other testimony today from anyone else out there? Representative Bonner, if you want to come back up and just close us out, please. Any other questions to the author? I know that there's one. We'll let you give some comments before you.
Well, thank you, Mr. Chairman. I appreciate the opportunity. I think we've all taken a lot of good notes over some questions and concerns to address in subcommittee. I will say that, part of the effort, and we obviously know that this is an issue, it's a problem, that it's more than just the metro area. And we know that what's been done to address this is simply to be going after the individuals themselves that are actually racing these vehicles. And I think that we can all agree that, as Butch mentioned, that does not necessarily address this issue of behavior. And so, it's not too often that two folks are going to just pull up to a street and decide to race each other and not film it, not advertise it, not publicize it, not get any benefits of the social aspects out of it. They're doing all that for that purpose. And so there's a lot of times, in most cases, these are events. These are centered around events, activities, actual promotions. And so that is the crux of what we're trying to address, is that this issue that we have today with folks doing this simply for the fact of promotion, drawing a crowd, putting these things on social media. And as we've seen, the result of this is danger to the public. And so I would simply submit that this is a way to go after the behavior that leads to danger to our public. And with that, Mr. Chairman, I'll address any other questions or concerns.
Okay. You have one question? Go ahead.
Thank you. I would like to know, where is noise addressed here?
So the noise itself is not addressed in this particular legislation. It is, every municipality, as you're probably aware, has various ordinances that speak to that. So this does not seek to address specifically the issue of noise.
Well, I will say that is like the biggest complaint of all, is a lot of people say, okay, and I do think a lot of this is a result of COVID and open streets. And once they have a taste of it, then they love it. The racing, it's an impulse thing. But so but what I've heard is that it's the noise more than anything. So I don't know.
The noise itself is, as you can probably imagine, is a much more slippery thing to address, because you've got to, it's one thing for you and I to hear a noise that may be sustained or may be annoying to us, but in most ordinances that I'm familiar with, they actually set specific decibel levels. And so you would actually have to go out and measure it at the time that it was taking place, and things like that.
Well, I think there is something about, you can go to the people that soup up the cars, and you can make, is there any penalty you can do to them? I don't know. This is something I'd like to, and I think Misha Maynor did, Representative Maynor has a bill. I haven't even looked at it, but I know it was addressing mufflers.
Yeah.
So.
Well, I appreciate that comment. I would say to that, what we're seeking to do is to punish unlawful activity. And so, for someone to have a hobby of fixing up their vehicle, to be as fast as they want it to be, or as loud as they want it to be, I personally would not want to inhibit that activity. But the moment that became an unlawful activity, I think that's where we need to kind of get involved. So
Thank you all for coming together today and hanging with us for 2 hours. We appreciate your time. Your time is the most precious gift you can give to anyone. No further business of this committee. We now stand adjourned.